Yes, the Eighth Amendment excessive fines clause should certainly apply to the states. In McDonald v. Chicago, rights that are deeply rooted in this nation's history and tradition and that are fundamental to the scheme of ordered liberty are appropriately incorporated and applied to the states via the 14th Amendment. Firstly, the excessive fines clause is indeed deeply rooted in this nation's history and traditions. Its history stretches all the way back to the 1215 Magna Carta, in which amercement for a small fault was prohibited. The 1689 English Bill of Rights re-established that excessive bail ought not to be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. The 1776 Virginia Declaration of Rights had nearly identical provisions. During the ratification of the Bill of Rights, the majority of states prohibited excessive fines, and by 1868, around the time of the 14th Amendment, nearly all states explicitly forbade excessive fines as well. The same goes for today. The prohibition of excessive fines finds its origins in the Magna Carta and has maintained significant importance throughout United States history. Secondly, the excessive fines clause is fundamental to the nation's scheme of ordered liberty. Excessive fines subvert and threaten other liberties. Anti-federalist Brutus stated that the prohibition of excessive fines was necessary for the scrutiny of liberty. The Eighth Amendment's excessive fines clause is both deeply rooted in this nation's history and traditions and fundamental to the scheme of ordered liberty. Thus, the Eighth Amendment excessive fines clause should indeed apply to the states. The Due Process Clause of the 14th Amendment addresses the states, saying that no state shall deprive any person of life, liberty, or property without due process of law. The Due Process Clause represents a legal obligation of states, guaranteeing legality and fair procedures. The Due Process Clause has been expanded to incorporate any right that is fundamental to ordered liberty, including rights such as those enumerated in the First Amendment. The Due Process Clause of the 14th Amendment, when considering stare decisis and future impact, is the most appropriate vehicle for applying federal constitutional rights to states. Stare decisis has well established the Due Process Clause as the vehicle for incorporation, although it may be contended that the precedent set in Slaughterhouse is an important consideration, but ultimately not an inexorable command in Lawrence v. Texas. One also must consider the future impact of incorporation using the Due Process Clause versus using the Privileges and Immunities Clause, which deals with the scope of the Eighth Amendment's prohibition on excessive fines. The Due Process Clause refers to any person, whereas the Privileges and Immunities Clause refers to citizens of the United States. Incorporation using Due Process Clause would extend constitutional rights to all persons, while the Privileges or Immunities Clause would grant protections to only citizens. Incorporation using the Privileges or Immunities Clause would create inconsistent standards on whether non-citizens can be unilaterally deprived of property without reason, creating a contradictory and confusing standard and scope.
In McDonald v. Chicago, this court held that the Second Amendment applies to states under the 14th Amendment's Due Process Clause. Justice Thomas, in a concurrence, argued that the Second Amendment applies via the 14th Amendment's Privileges or Immunities Clause, stating that, quote, any serious argument over the scope of the Due Process Clause must acknowledge that neither its text nor its history suggests that it protects the many substantive rights this court's cases now claim it does, end quote. As a substantive right, Justice Thomas argued that the Second Amendment question posed in McDonald v. Chicago offered an opportunity to re-examine and begin the process of restoring meaning to the Privileges or Immunities Clause. The appellant proposes that the case before this court today presents an opportunity to reverse the determination of the Slaughterhouse cases, which voided the Privileges or Immunities Clause, and return meaning to the clause by using it to incorporate the Excessive Fines Clause. The question presented is whether the Excessive Fines Clause is a substantive right or a procedural protection. Under stare decisis, it is clear that this court has deemed the Excessive Fines Clause a procedural protection, as the government may impose fines as long as it follows a fair, appropriate procedure. As said in Waters Pierce Oil Company v. Texas, quote, the fixing of punishment for crime and penalties for unlawful acts is within the police power of the state, and this court cannot interfere with state legislation in fixing fines or judicial action in imposing them, unless so grossly excessive as to amount to a deprivation of property without due process of law. Yet, as stare decisis is not an inexorable command, This question shall additionally be tackled through two modes. First, a historical understanding of the origin of the excessive fines clause, and second, a reading of United States v. Baja Cajun, a case considering the excessive fines clause, in which Justice Thomas himself authored the majority opinion. The phrasing of the Eighth Amendment stems from the English Bill of Rights, passed in 1689, which reads that excessive bail ought not to be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. Furthermore, fines and forfeitures of particular persons before conviction are illegal and void, a guarantee of a court procedure justifying the fine. These similar declarations each represent a concern for due process. The latter requires due process when assessing fines, as one must be convicted of the crime for which the fine is imposed, and the former requires due process when determining the amount of the fine. In U.S. v. Baja Cajun, the respondent failed to report that he was carrying money in excess of $10,000 on an international flight. The government sought a forfeiture of about $350,000, the total amount the respondent was carrying. Justice Thomas, writing the majority of opinion of U.S. v. Baja Cajun, ruled in favor of the respondent, noting, quote, "The maximum penalties that could have been imposed under the sentencing guidelines, a 6-month sentence and a $5,000 fine, confirm a minimal level of culpability and are dwarfed by the $350,000 forfeiture sought by the government." Justice Thomas continues that there was minimal harm done by the respondent's actions, which were solely a reporting offense. Hence, no aggravating factor existed to justify the vast amount by which the fine exceeded the maximum fine of $5,000. Furthermore, Justice Thomas noted, the money could not be forfeited because the previous arguments in favor of the full forfeiture argued that the money was instrumental to the crime. Justice Thomas declared, quote, "Because instrumentalities have historically been treated as a form of guilty property forfeitable in civil in rem proceedings, it is irrelevant whether respondent's currency is an instrumentality. The forfeiture is punitive, and the test for its excessiveness involves solely a proportionality determination." This court found that the law by which the government considered instrumentality was incorrectly applied. The true test for the fine's excessiveness did not include instrumentality. Instead, it, quote, "solely a proportionality determination," end quote. The government had incorrectly applied the law, or, alternatively, failed to provide due process. Furthermore, as previously mentioned, the excessive fine was a deviation from the procedure required because the previous courts failed to consider mitigating factors, like that the respondent's actions caused minimal harm. Justice Thomas's arguments against substantive due process do not apply to this case because the excessive fines clause, unlike the substantive right to keep and bear arms, is a procedural protection that fits under the limited scope of the due process clause. Justice Thomas's own argument in U.S. v. Baja Cajun illustrates that the excessive fine was a result of a lack of due process in considering proportionality, as the respondent's actions caused minimal harm, and the applicable law, as the concept of instrumentality did not apply because the forfeiture was punitive in nature. Likewise, precedent in Waters Pierce Oil Company and the historical concerns about due process with regards to fine in the 1689 English Bill of Rights all point to the same determination. The excessive fines clause is a procedural protection. As a procedural protection, the excessive fines clause fits into the narrow category of protections that must be incorporated using the due process clause. Indeed, the appellant seeks to use the privileges or immunities clause in a way that Justice Thomas himself warns against when he wrote that, quote, "We should also consider whether the clause should displace, rather than augment, portions of our equal protection and substantive due process jurisprudence." The majority's failure to consider these important questions raises the specter that the privileges or immunities clause will become yet another convenient tool for inventing new rights. Incorporation of the excessive fines clause using the privileges or immunities clause would ignore the distinction between substantive rights and procedural protections and simply replace substantive due process with yet another convenient judicial tool, perhaps to be termed procedural privileges. Instead, this court court must consider the key difference between McDonald v. Chicago in this case. The right to keep and bear arms is a substantive right, whereas the protection from excessive fines is a procedural protection. One must also consider the impact of incorporation via the Due Process Clause versus using the Privileges or Immunities Clause. A key difference lies between the phrasing of the two clauses. The Due Process Clause refers to any person, whereas the Privileges or Immunities Clause refers to only citizens of the United States. Thus, incorporation using the Due Process Clause would extend the Excessive Fines Clause to all persons, while the Privileges or Immunities Clause would grant protections only to citizens. Because the Eighth Amendment's Excessive Fines Clause doesn't include any stipulations about citizenship, incorporation via the Privileges or Immunities Clause would create an arbitrary qualification for the protections of the Eighth Amendment. Moreover, changing the doctrinal basis of incorporation from the Due Process Clause to the Privileges and Immunities Clause would lead to confusion over which constitutional rights apply only to citizens and which apply to all people. In United States v. Wong-Kim Ark, the court ruled that the term person in the Fifth Amendment applies to aliens residing in the United States, which is a sentiment repeated in Plyler v. Doe and Zedvitas v. Davis, in which this court asserted that the Due Process Clause applies to all persons within the United States, including aliens, whether their presence is lawful, unlawful, temporary, or permanent. As such, non-citizens have protection against any deprivation of life, liberty, or property without due process of law, the Fifth Amendment, a right that encapsulates the Excessive Fines Clause, which protects from a deprivation of property without due process of law, which was the phrase the court used in Waters-Pierce Oil Company v. Texas. Hence, incorporation using the Privileges or Immunities Clause would create inconsistent standards on whether citizens can be unilaterally deprived of property without a lawful reason. Ignoring the other differences between the Excessive Fines Clause and the Due Process Clause, this court is presented with an additional question. Should non-citizens enjoy equal protection against excessive fines? As mentioned previously, stare decisis demonstrates that they must. Yet on a strictly hypothetical level, the answer is the same. A visa holder, as well as every other non-citizen, must enjoy the equal protection of the Eighth Amendment. In 1854, Secretary of State William L. Marcy expounded upon the duty the federal government owes to non-citizens, especially those permanently living within the states. He says, the right to protect persons having a domicile, though not native-born or naturalized citizens, rests on the firm foundation of justice, and the claim to be protected is earned by considerations which the protecting power is not at liberty to disregard. Such domiciled citizen pays the same price for his protection as native-born or naturalized citizens pay for theirs. He is under the same bonds of allegiance to the country of his residence, and if he breaks them, incurs the same penalties. He owes the same obedience to the civil laws, and his property is, in the same way and to the same extent as theirs, liable to contribute to the support of the government. In nearly all respects, his and their condition as to the duties and burdens of government are undistinguishable. So with this understanding of the rights owed to non-citizens, this court has ruled that many legal protections apply to all people. Miranda rights apply to all persons equally, regardless of citizenship status, as do the rights enumerated in the 4th, 5th, and 6th Amendments. Habeas corpus rights have been held to apply not only to non-citizens, but even to non-citizens on foreign soil, in Boumediene v. Bush. The protections against cruel and unusual punishments, another clause of the 8th Amendment, applies to aliens as well under Robinson v. California, as it is this court's understanding and precedent that other sections of the 8th Amendment apply to all people. Limiting the Excessive Fines Clause to apply to only citizens would create contradictory and confusing standards, given that no person should be subjected to cruel and unusual punishments. Follows that no person ought to suffer the burden of an excessive fine. Additionally, since non-citizens have the same due process rights as all citizens of the United States under the Fifth Amendment, save in matters of immigration, denying to non-citizens a very specific due process protection against excessive fines would be a strange illogical choice. No need or justification drives such a choice, save the unjust extortion of funds from such non-citizens, including lawful residents with visas. Yet this is precisely what incorporation via the Privileges and Immunities Clause would do. It would posit that even though non-citizens have the same due process rights as citizens in all matters except on immigration, non-citizens lack the specific protection against excessive fines, even in non-immigration matters, which is an untenable argument. As a procedural civil right, the excessive fines clause ought to match the scope of other procedural civil rights in the precedent set by Wong Kim Ark, Zaidvitis v. Davis, Boumediene v. Bush, and many other cases. Incorporation through the Privileges or Immunities Clause would only allow citizens protections of the excessive fines clause, an untenable distinction. Non-citizens, since they have the same Fifth Amendment right to due process, ought to also have the more specific due process protection against excessive fines.
Assuming the excessive fines clause is incorporated, the forfeiture of Mr. Timbs' vehicle is certainly an excessive fine. Mr. Timbs used his father's life insurance proceeds to purchase a Land Rover for approximately $42,000 in January of 2013. After his arrest, a trial court accepted a plea and sentenced Timbs to 1 year of community corrections and 5 on probation. Timbs agreed to pay police costs of $385, an interdiction fee of $200, court costs of $168, a bond fee of $50, and $400 more for drug and alcohol assessment. The state also sought the forfeiture of Mr. Timbs' Land Rover, but a bench trial concluded that this was excessive under the Eighth Amendment, saying, in quote, "The amount of the forfeiture sought is excessive and is grossly disproportionate to the gravity of the defendant's offense," end quote. The trial court observed that the maximum statutory fine for his felony was only $10,000. Timbs' vehicle was worth about 4 times more when he bought it a few months prior to his arrest. A court of appeals affirmed, but the Indiana Supreme Court granted transfer and reversed the trial court's judgment. The Indiana Supreme Court contended that the U.S. Supreme Court had never enforced the excessive fines clause against the state and did not prohibit local or state laws from imposing excessive fines. With the assumed incorporation of the excessive fines clause, the trial and court of appeals decision stands. Keeping in mind that the Eighth Amendment applies to asset forfeiture as seen in Austin v. United States, and noting that the value of the vehicle was 4 times more than the maximum penalty and 30 times over the fines he actually paid, the fine is therefore excessive in the context of the Eighth Amendment's excessive fines clause.
So are civil forfeitures ever appropriate as punishment under the excessive fines clause? The answer is a clear yes. This court ruled in Austin v. United States that a civil forfeiture is appropriate as long as it's not excessive to the crime, meaning that there must be some degree of proportionality between the severity of the crime and the severity of the civil forfeiture.